before. We've been doing these interviews for several years now. We, the Asian American group. Is it on? Did we just record all that fun stuff? Good. Good. That's a little more natural. We do these interviews both for the primary as well as the general. So if you do go through to the general, we'll be meeting again with whomever you're going up against, and same invitation, probably going to be doing it here or somewhere similar. So this might not be the last time you see us even this year. So welcome to the political rat race.
Can I ask you a question?
Of course.
Do you guys make a pre-primary endorsement?
We do. We do endorsements for the primary. We generally will endorse 2 people through the primary, obviously down to 1 for purposes of the general.
Good.
What we do is, in addition to contacting the individuals who we endorse, we also get ad space donated to us in various Asian newspapers and periodicals, and we'll essentially put out like a slate card and then send out reminders to those people, hey, early voting starts whenever it does, the general election is whenever it is, or the primary I should say, please get out and vote. We also, amongst people at this table, probably have upwards of 8,000 to 10,000 email addresses, and we blast out that information to all of them. And we do the same thing for the primaries as well as the general. So, also, and I don't know if we're going to be doing it this year. In the past, for the general election, possibly this year for the primary, I don't know if you're aware of this, in Chinatown, the early voting booth is literally in the main area of that mall.
I didn't know that.
102 feet.
It's 102 feet away. Literally, it's only 112 feet from where you're sitting, because they mark it off because you can't campaign within 100
Larry
feet.
Lomax came and measured it himself a few years ago. Yeah.
So what we do on the first day of early, or the first Saturday at least of early voting, we have an event. In the past, what we've done is we've rented the far room here in Harbor Palace. Free food for everybody who wants to come down. Candidates who we endorse obviously are invited. We feed the masses as much as they want to eat, and then we say, here's our slate card. By the way, if you want to go vote, you can do it. Right? We don't care where you live. You can do it right there.
Great idea.
Come back with your sticker. We'll give you a high five. Happy trails. Goodbye. So we do try and get the vote out. I've had a pretty good track record in the past. Mike likes to say it's somewhere between 85 and 90%.
The last election was 85, the one before was 90%.
So
The last 10 years we've been having 85 to 90%.
Yeah, I'd read 70 to 75, but everything I read now, they're expecting a very low turnout for this primary, so it could be much higher than 75. Some of the early ones.
So we're going to get the word out, because we're going to get the colonization community, because it's going to be the Chinese paper, in newspapers, because most of the Asian people, they read the newspapers. That's number one. Every weekend they're looking to every Thursday the newspaper. Chinese, the Korean, the Thai. So that's what we're going to put in Chinese papers, Filipino papers, Thai. So that's why you're going to market our people who we endorse, and promote them for the primary and the general.
Well, that's important. We need reach in Clark County. That's the problem with judicial elections. The county geographically is so big that it's hard to get the reach. And then, of course, with the 52 judicial positions that are up, it's hard to raise the funds to get the reach. So any potential reach is very, very important.
So, first question we're generally asking most people we've interviewed is this. Obviously, you're running in Department L. Why have you chosen this particular time to run in this particular race?
Okay, a couple of reasons. First off, I was contacted probably 6 to 7 years ago by a group of attorneys to run. I personally am a firm believer that a person should have 20 years of practical trial experience before becoming a judge. At the time I was previously contacted, I didn't have the 20. I've now been practicing for 22. I'm going into my 23rd year of practice. I think it's a good time based upon my experience. This particular department, I actually considered quite a few departments, but I chose this one for a couple of reasons. Reason number one, the way the department is the business of the court as it's currently being conducted, I disagree with, to be quite honest with you. I am an attorney, I'm a trained trial attorney, and I believe a courtroom should be handled from a very traditional perspective. I don't think the business of the court is being conducted in from a traditional basis right now, and I don't think it has been for the last 11 years. The incumbent is by training, of course she was an attorney, she practiced law for a couple of years, but the incumbent is by training a therapist, a counselor, whatever it is you want to refer to. I think there has been, I'm going to be honest, I think it's an 11-year social experiment that just hasn't worked. The business of the court is being conducted in a fashion right now where everyone is encouraged to get along. Let's all get along. And the reality of the situation that the family court is faced with, people involved in contested domestic cases are involved in some of the most emotional times of their lives. And when people get to the point where they go before a judge in these domestic cases, the judge can talk till he or she is blue in the face, and the judge can say, pretty please get along, and try to get this resolved between yourselves, and utilize the services of this counselor and this therapist. And with all due respect, this does not work. What people in a contested domestic case need is a judge who has the strength, the conviction, the ability to make a decision to move them through this system. There's a little analogy that I'm going to use, and this tells you exactly why I'm running for this particular department. I'm not a fireman. I've never been trained to fight fires. However, I believe if the fire department gets a call for a fire, they go out to the location. Let's say it's a house is on fire. They have one of two choices to make. They try to put the fire out as quickly as they can, or they step back and let the fire burn itself out. Two simple choices. The problem is if you step back and let the fire burn itself out, it typically destroys everything in its path. That analogy is directly applicable to the family court system, and I say that sincerely. People, like I said, it's one of the most emotional, sometimes irrational times of a person's life. And if a judge does not have the conviction to enter an order, the determination to follow through with that order, to tell people how they have to live at that particular time, they just continue and they burn each other up. They just continue to fight and return and return and return. And honestly, that's the primary reason why I chose this department. There are a lot of other issues. I'm sure you guys have heard about the attendance issues and things along those lines. I can speak to that a little bit. I've actually contacted the Supreme Court, the Office of the Supreme Court, to get documentation to confirm attendance. I'm told the documentation exists. If I come to Carson City, they'll let me see it, and I can request copies. So who knows there. There's a very important issue raised by the attendance issue. It's not the attendance itself, it's the fact that it's become an issue. This should not be an issue. A judge is elected by the voters of Clark County, Nevada, to appear on the bench and perform a job. I have practiced law 22 years. I can look you all in the face and tell you in 22 years, I don't think I've missed 7 days from my office because I was sick. I go to work, okay? And so regardless if the incumbent comes in and says, I have a document, I saw this on a video, I have a document from 2013 where I only missed 3 days. Well, first off, I would hope in the year preceding an election year, you'd be a little bit more conscientious about your attendance. But the reality is, if we go back to 2010, 2011, and probably 2012, the fact that this has become an issue is something that the voters need to know about, and the voters really need to take into consideration.
You know, a lot of, obviously you're in the trenches in family court much more than I am. God bless you for it.
So just so you know, I probably try. I would venture to say I've tried between 400 and 600 cases. So I'm a trial attorney, that's what I do.
And you do have that, I'll say, you know, on the record, you do have that reputation. I mean, it's not you advocate for your clients. That's difficult in many situations you encounter, but
yes.
We'll skip the platitudes. Obviously, a lot of people don't know, civilians, for lack of a better term, don't really have a lot of insight into the judiciary as a whole. You've mentioned a few things that most average people who will be voting in this race, not only in the primary and the general, they know neither here nor there of anything. The only real window they have is the much vaunted RJ evaluations every 2 years. What ideas do you have to either supplement or modify or just increase the amount of information that the public in general has regarding their judiciary, either through these evaluations or
I was asked the same question by another group, to be honest with you.
Oh man, I thought we were special.
No. This is my response. And right now I'd like to focus on the RJ survey. Okay, the RJ survey is a biannual survey. The results come out typically in December. Okay, I have proposed that the survey be published more frequently. The response I get is, do you mean we should do it more than every other year? No, that's not what I said. That's not what I said at all. What I'm saying is you take the results of the survey that were published in December of 2013, the voters are not going to review that survey with the primary being 6 months later and the general being 11 months thereafter. I think it would help a lot if the results of that survey were published, okay, in December, but come back and perhaps on a quarterly basis. We don't have to redo the survey, but we can publish it on a quarterly basis. We can publish it on a every 4-month basis. Now I say we, of course that falls upon the ORJ, but I don't see that being that expensive of an endeavor. Let me stop right there and just point something out. The position that the department that I'm running for in the last 2 judicial surveys, and I'm using an average. One time it was 41%, one time it was 39%, but it's an average of 40% do not retain. Now I'm not going in and pulling every little line item. 40% do not retain. Now I guess I'm a little older and I went to school a few years ago and we changed some of the things in school, but when I went to school, if you had a 60%, that was an F, you failed. And I think the voters of Clark County need to know that. How do we get that across to them? I don't know. The only other thing is for individual candidates to make as much known to the public by various media sources as we can. But of course, there's a lot of issues related to that, primarily financial or monetary issues in getting the word out. So, but I think a very good place to start would be the judicial survey, publishing the results on a more frequent basis, for lack of a better word. Because I got to tell you, as a voter, of course, I'm involved in the system, but putting myself in the place of someone that's not involved in the system. If I was about to go to the mall to early vote on May 27th, and I had looked at that, the results of the survey on May 25th, I can tell you that would have a lot to do with me going in there and pulling a switch. And I think the average person would feel the same way. I think the lack of, I'm going to use the word transparency, I don't know if that's really the right word for this, information. The lack of information that's available to the voters of Clark County with regards to judicial races probably has a little something to do with many of the negative survey results that we see. Am I making sense?
Yeah.
Because people don't know, they typically vote blindly. If you vote blindly, I think you're more likely to get someone that's less qualified for a position.
We haven't addressed this in this race with you. I do want to tell you, I mean, I have maybe a half dozen family law cases, and I regret taking each and every one of them.
I tell people, I tell people all the time, 55% of my revenue, 80% of my heartache.
That's, yeah, fair estimate. I have no active case in front of Judge Elliott. I don't even remember the last time I was in front of her. And I'm doing that for most races. I lead with that, just to inform everyone involved. And we had Judge Elliott here, 2 weeks ago, and I said the same thing with when Ms. Perry was here as well. I said, hey, I got nothing in front of you, so just for your edification as well. I always divulge these potential conflicts, but I'm so infrequently do I go to family court. It hasn't been a problem with any of the primaries, so I just wanted you to know that also. You have a good amount, we pulled a little information on you before we had you come down. You have a good amount of experience, not only as a trial attorney, but also working as a hearing master in the truancy department, if I'm not mistaken.
I've done truancy, I've done abuse, neglect, I've done small claims, which, by the way, small claims is a lot of fun. When you watch Judge Judy, it's very similar to a lot of fun. But yeah, I've also served as a CASA, a court-appointed CASA, which was, I would encourage.
What's a CASA for everyone else?
A court-appointed special advocate. What happens is there is a person, does not have to be an attorney, can be any person. Of course, you got to go through certain qualifications, but you get appointed to a child, and you actually meet the child, interview the child, interact with the child, and you represent the position of the child to the court. You're basically speaking for the child before the court. I can tell you that 99. No scientific study. 99 of 100 people that I speak to that have served as CASA volunteers find it to be a very, very rewarding experience. But I've done some of that. Yeah, I've done a lot.
Based upon the various perspectives you have within the legal field, What do you see as the biggest inefficiency down at family court? And assuming you're elected, how are you going to fix it?
Well, first off, if I'm elected, I only control one department, okay? I see a lot, I'm going to be honest, I think the majority of cases, and I won't give you a percentage, but it's well over 50% of the cases that go before the family court, in my opinion, should be set for trial within a period of 6 months. Okay. Now, you guys as laypersons are going to sit back and say 6 months. Wow, that's a very, very quick trial setting. Okay. Now, of course, you have exceptions when you have businesses involved and you have to have valuations and stuff. Those are naturally going to take more time. However, when the majority of the cases over there involve children. Okay. Now, we have clear law in the state of Nevada that child issues need to be resolved before property and debt issues. However, a lot of these cases, we combine the issues and we get them resolved at one time. One of the inefficiencies that I see, and let me preface this by saying one other thing. We have another rule that says when child-related issues go before the court, we have mandatory mediation before the Family Mediation Center, because I think as a system, we believe that parents should have the first opportunity to determine what's in their children's best interest before. However, cookie-cutter way these cases are handled. Two clients, a man and a woman, 2 children. The family court has the power to resolve any issues on a temporary basis. We do it by way of motion practice. Now, I practice downtown also, and I don't do much motion practice downtown because I tend to represent the everyday average Joe. And I believe motion practice downtown is sort of a waste of money. The defense attorneys I see doing more motion practice. Family court, it's a wonderful idea, because what happens is you typically have a husband and a wife, a mother and a father who are at odds. From the day the initial motion for preliminary relief is filed, you typically get a hearing date in about 30 days, depending upon the individual judge. It's very, very important. I remember during the first, I was in law school, the first Gulf War, I remember turning on TV and seeing George Bush talking about the line in the sand. We have drawn the line in the sand. That initial hearing date is pretty much the line in the sand. Because what happens is the parties go before the judge that first time, not for final orders, but for temporary orders. And that gives the judge the time to usurp. A lot of these cases are about control. Men trying to control women, women trying to control men. It gives the judge the opportunity to usurp control over the case, explain to the parties permissible conduct versus impermissible conduct, and more importantly, explain to the parties the consequences of not following the content of the order. From that point, they're typically referred out to the Family Mediation Center with a return date, typically 30 days, depending on how busy they are. However, I think it would be much more efficient. We're required to have initial discovery conferences, 16.2 conferences. If you use that initial appearance as the date for the 16.2 conference, and you give the parties a trial date of that time, and you structure your calendar in an efficient fashion, you get these cases moving through, because now, not only do we have that initial line in the sand for temporary orders, we have that trial date set for final orders, and I think it would be much more efficient to do that. I'm going to throw another number out, and I had the research in my office. I didn't bring it. I believe this department in 2013, I don't want to misspeak, set 120 cases for trial. Now the layperson steps back and says, wow, 120 cases for trial. Any research that you conduct is going to tell you that between 60 to 80% of the cases that are set for trial, that have that line in the sand, will settle prior to the time of trial. So if you look at the comparisons of this department, if you look at this department in comparison to other departments for the number of cases that are set for trial, you're going to see what the efficiency issue is with the department. See, what's happening now is referring out for services, try mediation. And I'm not saying I'm not a fan of ADR. I'm not saying that at all.
Alternative dispute resolution.
Yeah. I'm sorry. But I believe ADR is very, very successful where parties agree to participate in ADR. So by no means am I saying no ADR. I'm saying that should be a decision that's left to the attorneys and the clients, not to me as a judge. My job as a judge, the voters are telling me, get these cases through the system. And you're only going to get these cases through the system if you settle the trial.
Do you happen to know the figures, ballpark, for the average Clark County Family Court judge for how many trials they sent?
I can tell you what I did. I looked at the research, and I'm trying to be as politically correct as I can. I looked at the research, and I compared this department to departments that I consider to be good, efficient departments. And I would say that the trial settings that I saw are probably 40 to 60% less than the departments that I consider to be efficient departments.
That's 40 to 60?
40 to 60% less.
Less.
So if, let's say there was 120 trial settings in Department L, I'm seeing 170, 190, 210 in some of the other departments. And that's what I'm saying. When you see 120, you think 50 work weeks a year. Wow, that's 2.5 a week. That's nothing. That's nothing. But of course, you have to be on the bench in order to set and conduct
So you're
trials.
saying out of the 120, what percentage again was going to settle before the trial?
Oh, at least, and I think at least 60% are going to settle.
Probably.
I would, if I'm judge, I'm probably going to stack 3 cases at a time. And what I mean by that is, at the initial hearing, I'm going to use it as a 16.2 conference. Okay, that's when we set up discovery times and stuff. But I'm going to say, okay, how much time do you anticipate you're going to need for trial? I'm going to need 3 hours. I'm going to need 1 judicial day. I'm going to have my calendar. Every time I make a setting, I'm going to do 3 separate settings. Okay. Now, a week before, I'm going to have a calendar call. I'm going to have a pretrial conference. But I feel confident that of the 3 that I set for trial, 7 out of 10 times, 6 out of 10 times, 2 of those 3 are going to settle, and I'm only going to have 1 trial set on that particular thing. But that's how you get people through the system.
Yeah.
You know, when people can't get, I guess, have any of you guys ever been divorced?
Yes.
Okay. I mean, people going through a divorce action,
Adoption.
people going through these contested actions have trouble agreeing that the sky is blue. I mean, they do. So the judge's job to get them through the system, in my opinion, first off, as efficiently, and I'm talking from a financial perspective too, all these return. Every time we refer somebody out to a counselor, every time we refer someone out for ADR, I hope you all understand, there's cost being imposed on those litigants, okay? And that's another problem I have. I think we've created kind of a cottage industry down there with these referrals that it's the job of the judge to make decisions in these cases. It's not the job of some outsourced evaluator to make decisions on behalf of the judge. Get to another efficiency, I believe, there too.
For everybody else's information, I have no active cases against Paul. None of my 6, I think it literally is 6 cases. None of them are against Paul. So there's no conflict there either. Usually I get conflict with my chin, but I don't think we've had a case against one another for
a long time.
Decade is my guess.
That's something. How long have you practiced now?
14.
I practiced 20. I'm in my 23rd. You know, when I moved here, it was a really great community to practice in. And what I mean by that is, we had a sufficiently low number of attorneys where almost everybody knew everybody, and there was a basic congeniality between attorneys. And now, I like to compare it to Southern California, although I've never practiced in Southern California, but we're becoming another mini Southern California. We have so many attorneys now that we don't see each other the way we used to. We don't develop those relationships the way we used to, and it creates a lot of...
That leads to problems.
I think it's called progress.
Not in every respect.
My progress with progress. It's still a wonderful place to practice law. St. Nevada is a great place to practice law. It really is.
I have asked the majority of the questions. I know sometimes you guys like jumping in. Any other questions or anything I haven't covered as of yet? Anyone? No one?
You know, I know the judge for almost since you heard the first time, and supported her in the first time. One thing we always ask all our judges when they get elected, we do judges night out, mediation committee, maybe 2 or 3 years. We do the last 10 years. And basically we get out of 70 judges, get maybe about 60, 65 coming. And we ask a commitment if you get elected, and if you join us. Like the judge, which we talking about yours, she has not come for a couple of events, twice, and I told her about it. In fact, we have a judges' night out on the June 5th,
Yeah.
and we have confirmed 59 judges already confirmed out of 75. And we are the only group who get so many judges coming and event to meet with the issue. So in case you get elected, we need a commitment that
Absolutely. I hope you don't hold against me what she has done. I mean, she
No,
and I are way different people.
Yeah.
I've heard I've heard similar things. I've done a lot of work with DFS and against DFS and workers, and I've heard similar stories. She gets involved to do certain projects and she just doesn't show up, and I've got no, I mean, I don't know how to explain. It's very, very, in my opinion, when you're a candidate running against an incumbent, it's very, very difficult to get people to support you against the incumbent. I can tell you, I have, and I didn't bring my letterhead with the people that are supporting me for you guys to see. I have some attorneys that I consider to be very, I don't want to use the word prominent, that's not, very good family law attorneys that are publicly supporting me for this department. I can't tell you the number of very good attorneys that have, you know, attorneys are always put in a precarious position. Do we publicly support and risk it? But I can't tell you the number of attorneys that have contacted me that won't go public. I don't know. There needs to be a change. Look, there's been an 11-year opportunity there, okay? An 11-year opportunity, and we're dealing with issues right now as silly as a judge's attendance on the bench. We're dealing with issues as silly, don't take this the wrong way, as a judge not honoring commitments to you guys. I mean, that's, you know, once again, I can't speak for her. That's questions she has.
No, we already discussed it.
But she and I are way different people, and I'm not trying to disrespect. That's not what I'm trying to do. I don't know her personally. I don't. You know, I don't. I've made numerous appearances before there. I'm always dejected when I feel like I leave court with nothing being resolved. How
often does it happen?
Frequently. Far too frequently. It's not only this.
That's the only family court, or is also as in district and justice court?
Well, no, I'm talking about this department right now, but there's other family court judges too. And once again, I mean, when you have, I just finalized a case, and it wasn't this department, another department. We have the 5-year, you know what the 5-year rule is. I just finalized a case. I was the second or third attorney involved in this case for one. I was the second attorney for this one side. I didn't even realize this because I hadn't filed the complaint. The day we went, we've already been set for trial 3 times. She doesn't want to try the case. We finally, I said, Judge, you can't do this. You got to try the case. I looked down. I go through the file. The complaint was 6 years old. This little boy was 2 years old when this case started. He's now 8 years old, and there's no excuse for that. That's the system failing. It is, and that's what a judge. You have to have conviction. Look, I'm doing this knowing, and family cases are a little bit different. I think a judge in a criminal case or a regular civil case makes a decision knowing that one party is going to typically be unhappy with the decision. A family court case, well, and what happens is there's not just this isn't running a red light. There's issues within issues within issues within issues. And but going into this, you have to know that typically when you make a decision in these cases, both sides are going to be unhappy. But if you make the decision, you're firm. People in family court cases need to be heard. All of my clients feel the need to be heard. And if you aren't setting trials efficiently, they don't feel like they're being heard. Okay? So they feel the need to be heard, and if you allow them to be heard, you explain your decision and the reasons for your decision, and most importantly, don't forget this, okay? You have to let them know that you're going to have a firm hand in implicating or enforcing your decision, and you have to take to task on that if it becomes necessary. But once they leave court, they're going to be, but they learn to live with it. They move on with life. They don't move on with life when you don't put out the fire. We don't put out the fire, they burn right up. Yeah, so that's what it is. So once again, I have nothing bad to say about Jennifer Elliott from a personal perspective. I'm talking about courtroom, the administration of the court's business is what I'm talking about.
Pretty much right at our time limit. Well, quick.
That was painless.
Relatively so. But appreciate you coming on. Thank you again.
Did you guys have any other? Can I just ask you